Hi, in today's discussion, I'll discuss whether or not you can file student loans in bankruptcy. In today's discussion, I'll discuss bankruptcy and student loans. Can you have your federal student loans discharged after declaring bankruptcy? In what circumstances do you need to prove to have your loans discharged in bankruptcy? There are some circumstances that you can have your federal student loan discharged after declaring bankruptcy. You may have your federal student loan discharged in bankruptcy only if you file a separate action known as an adversary proceeding, requesting the bankruptcy court find that repayment would impose undue hardship on you and your dependents. Discharge in bankruptcy is not an automatic process. You must declare Chapter 13 or Chapter 7 bankruptcy and demonstrate that repayment would impose undue hardship on you and your dependents. This must be decided in an adversary proceeding in bankruptcy court, and your creditors may be present to challenge the request. Bankruptcy courts determine undue hardship. For a bankruptcy court to take your side, you will have to meet specific conditions. The problem is that there is no uniform set of conditions. The bankruptcy courts do not use a single test to determine undue hardship, but may look at the following factors to determine whether requiring you to repay your loans would cause undue hardship. Like if you're forced to repay your loan, would you not be able to maintain a minimal standard of living? If forcing you to repay your loans, is there evidence that this hardship will continue for a significant portion of the loan repayment period? So like if your loan repayment period is 10 years and they can't see from now until 10 years from now that you'll ever be making more money than what you're currently making, or you'll ever be able to afford to make your monthly payment, then that might be considered undue hardship. Did you make good faith efforts to repay the loan before filing bankruptcy? Like, did you just graduate and then now you're filing bankruptcy? Then you didn't make a good faith effort because you just got into repayment and you didn't explore your options in terms of deferments, forbearances, and income-driven repayment plans. What is a minimal standard of living? The bankruptcy court will determine what a minimal standard of living is, but this could mean that your income has been at or below the poverty level for a while and shows no signs of improving. You have a spouse or child with a serious illness that requires round-the-clock care. You are on public assistance and or receiving disability checks as your only source of income. You have become permanently disabled since taking out your loans. As you can see, there's a common theme, and that is your situation is unlikely to improve in a way that will allow you to repay your debt. When the courts examine your expenses, they will be looking at the cost of reasonably priced necessities. Like eating caviar dinners and taking fancy vacations aren't considered necessities. What they'll be looking at is your cost of food, your cost of utilities, your cost of your apartment, and things like that that are considered necessary for everyday life. If you are permanently disabled, consider taking out a total permanent disability application instead. And that is because if you are permanently disabled, you might qualify for a discharge through that program. I list the link below and on one of the last pages of this presentation for you to find out more information about that program if you think that you might qualify. What happens to your loan if the bankruptcy court determines repayment would cause undue hardship? It all depends on the terms of the bankruptcy court's determination. The terms may include the following. Your loan may be fully discharged and you will not have to repay any portion of your loan, and all collection activity will stop. Your loan may be partially discharged and you will be required to pay some portion of the loan. Or you may be required to repay your loan but with different terms, like such as a lower monthly payment and a lower interest rate. Now what happens if the bankruptcy court decides you don't have undue hardship and you still can't afford your payments? If that does happen, what you could do is apply for different repayment plans that might exist for your loan. Especially if you have a federal loan, they have a lot of repayment options like income-driven repayment options. They also offer deferments and forbearances. So that's something that you might actually want to consider before filing bankruptcy, because if you meet the eligibility for one of those, you might not need to file bankruptcy in the first place. What you should consider before filing bankruptcy on a student loan. The number one thing you should consider is student loans are way harder to get charged than any other type of unsecured debt, but it is sometimes possible. Before you consider declaring bankruptcy for a student loan, consider your options. You may be eligible for an income-driven repayment plan, a deferment, or forbearance. If you're eligible for one of these options, it might be a better route to go because your circumstances might change in 6 months or a year from now, and you may regret filing the bankruptcy at that time. If your student loan is your only debt, you may not want to file bankruptcy. And the reason is like I stated earlier, is that you might qualify for an income-driven repayment plan, deferment, or forbearance. And there's a good chance you may not win your case in court because the Department of Education and the courts are going to look at your eligibility for deferments and forbearances and income-driven repayment plans. And if you qualify for one of those, they're going to ask why didn't you apply for one of those instead. Or they might look at you filing bankruptcy as just a way or a strategy that you took, just trying to get your loans discharged, and they probably will just deny your claim. I'm not saying that they will, but there's a good chance you'll get denied your claim for bankruptcy on your student loans. Another thing is, you may have a better chance to discharging or settling on a private loan than a federal loan. That's because like a federal loan is through the Department of Education, and they have more options available for those loans with the income-driven repayment plans, the graduated repayment, extended repayment, deferments, forbearances. There's so many different options that are available for a federal loan. But for a private loan, there's not as many options available. So those companies that hold your private loan may be more willing to work with you to compromise on a lower balance, or work on you with the bankruptcy to get it to a point where you can afford it, just because of the fact that some money to them is better than no money at all, and those loans are not guaranteed for them. So like if you defaulted on a private loan, chances are there's no guarantee for them to get the money back at all. But on a federal loan, if a servicer has that loan or a lender has that loan, the Department of Education pays them a portion of the loan back. If you do file for bankruptcy and are considering applying for the adversary proceeding to include your student loan, find out if your bankruptcy lawyer has experience getting student loan debt discharged. And the reason being is because you want an expert to review your situation to see whether or not you're going to qualify for the discharge, because why file for the bankruptcy for the student loan if there's not a chance or possibility that you're going to get discharged anyway. And that's especially true like if your main debt that you're trying to get discharged is your student loan. You want them to review all this before you even file, because why waste the money for the court costs and the fees if there's not even a possibility that your loan is going to get discharged. On this page, I just wanted to list some of the helpful websites. The first link is for the total permanent disability, and that just gives you more information about that program. The second link is for the different repayment options, and the third link is for the income-based repayment options. And the last link is more information about student loan bankruptcy. And I just would like to conclude by saying that all the information that I have listed here is not all-inclusive, and only the courts can determine if you're eligible for undue hardship and discharge of your student loans. But you might also want to discuss with a lawyer whether or not you're eligible for the discharge, because why pay the fee to get your loans discharged in bankruptcy court if you're not going to be eligible? So I would consult with the lawyer first if you're just thinking about applying for bankruptcy for your student loans. And please keep in mind also too, if your student loan is your only debt that you're applying for bankruptcy for, there might be a good chance that you might not qualify for the discharge. And especially if you don't have undue hardship, because that's the main determining factor is undue hardship. No undue hardship, no discharge. Thank you for watching the video. I hope that you found the information useful. If you could please like and subscribe to my channel and share the page with others that you think might be interested in the information. And until next time, thank you. In my upcoming presentations, I'll discuss student loan types, student loan consolidation, other useful websites, and in my prior presentations, I've discussed deferment and forbearance options, repayment options, how to apply for financial aid for college, and student loan forgiveness programs. I went into further detail of the nursing student loan forgiveness program and the teacher loan forgiveness program because I thought that their information was useful. Thank you, and until next time, thank you.